So I'm not sure if everybody knows what we do at the Institute, but we're essentially a network of lawyers and academics. And we've been working since 1989 to come up with progressive alternatives to some of the neoliberal policies that come out. So on the issue of fire and rehire, I should say I'm not a lawyer, unfortunately, but what we did do was get submissions. We asked for submissions from our experts when we realised that fire and rehire practices were blowing up during the pandemic, and also when we knew that politicians in the SNP and Labour were looking at ways to legislate against that practice. So what I'm going to take you through, and I'm going to try not to repeat too much of what Rebecca said, is just some of the points that our experts made, largely to do with, you know, the law behind this, the legislation, but also some kind of tips as to what unions can do, even under the current law, and reforms of the law that our experts think could improve things in the future. So I should first of all just let you know, all of these points are coming from a mixture of Professor Alan Bogg, Professor Michael Ford QC, Professor Keith Ewing, and Joe Seary, who is with Thomson Solicitors. So I just want to start off with some of the points that our experts made more generally, which in particular Joe said that from where she's sitting, collective bargaining has really been instrumental during the pandemic, because really employers kind of have a choice between collective bargaining and fire and rehire when it comes to economic downturns as big as this, and the potential need, which there sometimes is, for reorganisation. There's been some really creative ideas from the unions as to how terms and conditions can be more flexible in order to keep the jobs, but without the need for things as bad as fire and rehire, and without people needing to lose a lot of pay. The other thing that I just wanted to say at first was it was observed, unfortunately, by Professor Alan Bogg, that the courts are normally very precious about the sanctity of the contract, but that seems to change whenever there's an economic downturn. So I guess he is predicting that the courts might be tough ground for the unions while we're going through a recession, where they have a tendency to start deferring to the employer, which they do already often in unfair dismissal cases. So I'll just start off with why employers are choosing fire and rehire rather than just changing the contract. I was told about one case, Rigby v. Ferodo, I think it is called. And in this case, the employer changed the terms and conditions of the contract, and the workers continued to work without having given like a written acceptance of that contract. They later went to court, and the court ruled that their continuing to work did not represent an acceptance of the new terms. And because of that, the workers were able to claim damages for the differences between the original contract and the amended one. So to avoid those kinds of legal uncertainties, then employers are just deciding, let's just explicitly dismiss everyone, and then re-engage on a new contract. Generally, they also give workers the opportunity to accept the new terms without having to lose their job first. But either way that the worker goes, it's the same thing. They are forced to accept new terms. So we heard from Rec about unlawful dismissal. There are actually three types of unlawful dismissal. The main one that you'd be looking at is unfair dismissal. In common law, there is a concept of wrongful dismissal. Unfortunately, this is very weak. So this holds that dismissal is lawful so long as the employer complies with relevant notice periods, and that's it. So that's not much help to us. The statutory unfair dismissal rules come from section 95(1)A of the Employment Rights Act 1996. As Rebecca said, there are a lot of qualifiers to this. So you need to be an employee, which is a person hired directly, so not an agency worker, for instance. You need to have been in continuous employment with the same employer for 2 years. And even then, it is quite difficult in these cases to get through the courts. So there are 5 different reasons an employer can give when they're challenged on this to say that a dismissal is fair. And as has already been covered, some other substantial reason is the main one that they'll use. So the other reason why some other substantial reason is quite a slippery idea is that it's decided whether or not it is a fair reason by what's called the band of reasonable responses. So the band of reasonable responses is essentially like, would other employers do it? So they can look at the kind of the range of responses other employers have had to the same problem and decide whether it's kind of normal. And that means that it's not that the tribunal is sitting there and deciding themselves, does this seem fair? Instead, they're saying, you know, is this normal in the current working climate? So that obviously means there's a kind of slippery slope there for dismissal reasons to get worse and worse. Just as an aside, Paul Scoley from Morris Solicitors wrote in a report for the IER that there was one case of unfair dismissal that the courts decided was fair, according to the band of reasonable responses, and that was that he had been fired by his employer because his employer smelled alcohol in his breath. It was then proved that it wasn't alcohol, he hadn't been drinking, and the smell was his aftershave. And the court decided that was a fair dismissal because they decided that other employers would have taken the same action. And I believe the judge said something like, this is on the very fringe of what would be reasonable. So that's a very extraordinary case, but he kind of managed to get through. So, so there are cases originally that found that dismissal was unfair because it was used only to increase profits. So it's a case called Catamaran Cruises Ltd versus Williams, where the original tribunal ruled the dismissal to be unfair, and it was a fire and rehire situation because it was only for the benefit of the employer. They weren't in a desperate situation. But unfortunately, the Employment Appeals Tribunal overruled and said it was a fair dismissal. And they were going off a previous case of Chubb Fire Security versus Harper. And that, quoting from that case, they said, it may be perfectly reasonable for an employee to decline to work extra overtime having regard to his family commitments. Yet from the employment point of view, having regard to his business commitments, it may be perfectly reasonable to require an employee to work overtime. So they decided this is a reasonable reason to dismiss someone, and therefore they are dismissed. So that decision, the Employment Appeals Tribunal decision, has that case law has kind of made courts more deferential to the employer. One way that Joe Seary from Thompson's told us that unions can potentially fight this is there is a requirement that the employer demonstrates that the changes they're making have discernible advantages to their business. So, as I've just said, this isn't really solidified in law, but it is a way for unions to push back. So one of the ways they can do it is that unions can force employees to try and demonstrate that there will be advantages, discernible advantages to the business, and that can help them reveal whether or not they're just using the pandemic as an excuse. So let's say they have got a lot of public money through some of the government supports loans that are coming in, or they've been using the job retention scheme. So they've got all of this support. Do they really need to be firing all these workers as well? And Joe Seary thinks that that is something that unions can look at and can really put a lot of pressure on the employer to show their figures and to absolutely concretely demonstrate that there's no other way. So there is some case law to say that the employer must take into account an employee's interests, and this can mean that you can make a case around the extent of disadvantage to workers. So some of what Rebecca was talking about how if they're dismissed or they have to accept these new terms, they're not going to be able to pay their mortgage, not going to be able to pay their rent, those kind of things. They must also act in accordance with equity and fair dealing. So this is from the case law, and basically what equity and fair dealing is you need to consider whose pay is being cut or whose terms and conditions are being reduced. Is it just workers or is it management as well? So if you can show that it's only workers or one section of workers, then you can build a case out of that. If management's pay is cut as well, then it looks more equal, but often they won't be. On to the last way in which there's law around unfair dismissal, which is the redundancy consultation procedures, as Rebecca's already talked about, section 188. So there was a ruling in the European Court of Justice which created section 195, which Rebecca has mentioned, which extends redundancy to mean any reason not related to the individual concerned. So that is section 195 is what you're relying on really if you're looking for union consultation on fire and rehire. So normally, so the duties to consult, as has been mentioned, is at least 45 days. That's actually for where there's 100 or more people losing their jobs. It's 30 days otherwise. So there is, I'm sorry, I'm just looking at my notes to try and find this, that there is, yes, so there is a EU law that is currently still active, which is the obligation to consult arises when dismissal is proposed. So this doesn't need to be like an explicit proposal. It could be argued, and again, this is Joe Seary's beliefs from Thomson Solicitors, that it could be argued that when an employer chooses to wind down their involvement in the furlough scheme, then you can kind of deduce that they're about to make a load of redundancies. So you can make the argument that the law obliges the employer to consult with reps and workers at that point and not wait until the redundancies are announced. So there is a legal duty to consult in good faith when you're looking at redundancies, collective redundancies. And this should be a meaningful consultation is basically getting through all the details of the proposed changes right at the start so that you've got a lot of time left over to really deeply consider alternatives, which we've already heard from Ian earlier isn't really happening, but you can push for that as being, well, this is what the law says, it has to be a meaningful consultation.
Sarah, sorry to interrupt you. You've got about 2 minutes and then we'll have to bring another speaker in.
So, yeah, of course. I'll just really quickly go through some of the reforms. So, one of the things that's important to say is that our experts don't think that banning fire and rehire is necessarily a good thing. If the law is too constricted, then that provides an incentive to employers to just shut down their business. So that could be counterproductive. So instead, what our experts say is that we should clarify the law around making a direct contractual offer to workers. So at the moment, there is a financial penalty if an employer kind of sidesteps the union, goes direct to the workers to make an offer, if it can be shown that their sole or main purpose was to avoid collective agreements. So it should, we think that should be changed to make it clear that the employer has to honour all of its commitments to the recognised trade union under a collective agreement. So basically making the law clear around that so they can't escape the agreements. Another thing is that they think that fire and rehire cases should be scrutinised in the courts from day one. So whenever they are announced that this is what the employer is going to do, the court should get involved. And that they should basically have the effect of holding the terms and conditions as they are until there's been a full hearing on the merits of the case before the employer is allowed to act. And the primary remedy, if it's decided that it is unfair, should be that people get their jobs back, although there could be some flexible adjustment to make sure that the business stays open. So we should turn back the tide on the catamaran case so that dismissal is unfair if there are economic alternatives. Should make that clear that you can't just use this to profit. We should have better legislation around employees demonstrating they've consulted with the representative trade union and that the trade union is in support of what they're doing. There should also so section 188 should be extended to everybody in employment, not just employees, and the thresholds that trigger consultation obligations should be reduced so that more people can benefit. Nearly there. So another one that I think is important is that they suggest that the government gather data on the extent to which fire and rehire has been used during the pandemic, and then these people should be named and shamed on the government websites. And just like Rebecca said, we also support the idea of public contracts should only be given to good employers, which excludes people who use fire and rehire, but also the government could look at withdrawing the support of business loan schemes and other types of financial support from companies that have used fire and rehire in an exploitative manner.